Atkinson, Andelson, Lawyer, Rood, and Romo is a full-service law firm with 150 attorneys in 8 offices throughout California. With over 35 years of uncompromising commitment to high-quality legal work and providing consistently practical management solutions to its clients, AALRR has earned a reputation as one of California's leading law firms and represents both private and public sector clients, with emphasis in the areas of employment, labor, construction, education, real estate, general business and business litigation, corporate, taxation, and immigration. Please visit AALRR.com for additional firm information. Thomas Lenz is a senior partner handling all aspects of labor and employment law for the firm's Cerritos and Pasadena offices. He heads the firm's Traditional Labor and National Labor Relations Board practice and works with employers in all major industries across California and the West. He is currently a member of the Executive Committee of the Labor and Employment Section for the State Bar of California. Tom has been named to the top 100 labor attorneys in the United States by Labor Relations Institute, Inc., a leading industry information source. He has also been named a lecturer in law at USC Law School.
Thanks, Robert. This is Tom Lenz of the Atkinson Andelson firm. I'm a partner in the firm's Cerritos and Pasadena, California offices. I practice labor and employment law. I've been with the firm about 23 years after beginning my career at the National Labor Relations Board. Most of my practice involves traditional labor law and work before the National Labor Relations Board. I will be talking today about National Labor Relations Board practice in a program we call Nuts and Bolts of NLRB practice. The National Labor Relations Board is a federal agency which has existed since the 1930s. Many times people think of it as an agency that deals exclusively with issues of labor unions. And many times people think that if a company is not unionized, or if I, an employee, am not a union member, that the National Labor Relations Board has no relevance. But that is actually something that in my practice I know not to be true. From my experience working at the National Labor Relations Board in the late 80s and early 90s, I know that's not true even going back to then. We're at a point when union density across the country is very low. In the private sector at the time of this recording, it's about 7% of the private sector workforce that's unionized. But the National Labor Relations Board is mindful of that, and they are also mindful of a mission to make sure employees have rights which are protected under federal law, and it is their job to enforce that law. And we will talk about what those rights are, what those processes are as we go through this program. So for you as an attorney, how relevant is the NLRB to your practice? If you represent employees or labor unions or employers like me, or maybe even other groups, could be civil rights, business-oriented, whatever it might be, there is potential relevance of the National Labor Relations Board to what you do. Employees have rights, which we will discuss. They are the cornerstone of the statute under Section 7 of the National Labor Relations Act, which the NLRB enforces. Labor unions will find relevance because of the employee rights I just mentioned, not to mention the process by which the National Labor Relations Board runs elections to bring in and certify a union, to remove and decertify an incumbent union. For employers who run businesses, hire and fire employees, and set wages, hours, and working conditions, the rights of employees, the coming and going of a union, the collective bargaining process are all potentially significant issues. How does an employer manage the workforce? How does an employer communicate with its workforce and its supervisors. These are issues which are relevant to the NLRB and to day-to-day business under this law. For other groups, civil rights-oriented groups, it could be groups that are focused on immigration rights. It could be groups that are focused on free speech. It could be a lot of different civil rights, anti-discrimination groups. The National Labor Relations Board is enforcing laws which affect those rights, and it's something that I think those groups would be interested in following and perhaps participating in the process where they can. For business-oriented groups such as chambers of commerce, industry groups, legislative advocates, there are significant issues here affecting the workplace, thereby affecting the economy. The NLRB is also relevant to you. Today in the media, we see lots of information about what the NLRB is doing if you know where to look. It frequently comes up in the Wall Street Journal, business publications, online, from whatever perspective you hold. The National Labor Relations Board enforces rights which protect employee conduct in the workplace. Typically, this is collective activity, where one employee tries to instigate others to engage in a certain type of activity affecting wages, hours, or working conditions, or where you have a group that could be pursuing some change in the workplace or might be trying to organize a union. With attorneys who represent employees, questions of group action and protection under the National Labor Relations Act are important questions, and these are important issues that should be considered in the issues you handle and advise on. Issues affecting more than one employee in a workplace are critical to this analysis and what's concerted activity, which may be protected. There could be issues involving a disputed workplace policy. If a policy affects employees on a broad scale, if it's something that more than one employee complains about, this is something that could bring about questions at the NLRB of interference with protected rights. If you have an at-will employment policy that runs afoul of certain standards the NLRB follows, that could be something that the Labor Board gets involved in. The Labor Board in recent years has looked at will employment language for interference with collective rights. Harassment investigation and confidentiality rules are also important to employees. The Labor Board has taken an active role in looking at how employers conduct investigations, instructions given by management to employees about maintaining confidentiality to avoid chilling rights of communication and concerted activity. If you have issues under a labor agreement or employment contract, sometimes they will touch upon the protected rights under the National Labor Relations Act, where there is something that controls, restricts, chills the exercise of NLRB rights. It may be a situation where the Labor Board wants to get involved to change that. Arbitration agreements are increasingly common, and employers like them because they are helpful in keeping disputes out of court, keeping resolution of matters quick and less expensive than what they might be if they went to court. And not surprisingly, the National Labor Relations Board, in protecting employees, has taken issue with the phrasing of arbitration agreements, particularly where such arbitration agreements forbid class action and other concerted efforts by employees to pursue their rights. Union organizing drives are probably what most people think of with the NLRB, and if you represent employees, that might be what first comes to mind. However, while it is an important set of circumstances for what the National Labor Relations Board and National Labor Relations Act cover, it is merely one of the different types of issues. If you represent labor unions, union organizing campaigns, of course, are important. Unions are looking to increase their statistics, their density, their membership numbers by having elections, by convincing employers to voluntarily recognize them as the representative of employees. Of course, collective bargaining is what a union wants when it represents employees, to be able to sit down with an employer and negotiate over wages, hours, and working conditions to try to reach an agreement. Representation of employee members is an issue which comes before the National Labor Relations Board. Let's say a union member has an issue, a grievance, or maybe they don't like the way their union dealt with a particular issue. These can be issues which arise between an employee and a union. Picketing and strikes, actions that are taken perhaps to put pressure on an employer when the union and its members do not believe that they are getting the best possible deal, or if they believe an employer is engaged in unlawful activity. These are the sorts of things which are regulated by this federal law and could come up if you represent unions. If you represent employers, issues of employee misconduct may involve the National Labor Relations Board. If you have an employee who says things that you don't like, that you think are disloyal, harmful to the business, they may be protected and concerted in the NLRB's view. Discipline and termination is something which frequently comes up, and employers need to be mindful of having consistent and lawful policies in terms of administering discipline and terminating people. In dealing with group action, it may be disruptive in your workplace, but you need to know how to handle it so you are not retaliating against protected activity and you are keeping the business running and serving your customers. In drafting workplace policies, the National Labor Relations Board, as I mentioned, looks at issues of language in a policy chilling protected rights. And if you're working with these issues on behalf of employers, you need to understand how to review, edit, and write policies which will not only get to the point where the employer wants to be in running the business, but will also satisfy the legal standards. In dealing with harassment investigations and confidentiality, you need to know how to investigate consistent with law other than the National Labor Relations Act. Of course, here in California, there are plenty of guidelines on conducting investigations, which frankly were created without much regard for the National Labor Relations Board, and that includes confidentiality. But the Labor Board has its own idea on what is appropriate in dealing with this, and if you advise or represent employers, you need to know how to reconcile those standards. Collective bargaining involves duties that are sometimes quite complex, and if you represent employers, you need to know about that process, turning over information, making and responding to proposals, among other things. And in dealing with picketing and strikes, you want to make sure employees' rights are respected, but at the same time that you run the business and that you have minimal disruption, and you do what you can to staff up, to do your job, to make money and follow the law. So we've talked a lot about the types of issues that can arise. What does the National Labor Relations Board protect in regard to these rights that we've talked about? Section 7 of the National Labor Relations Act is the key cornerstone to this law. And Section 7 provides employee rights to form and join labor organizations, which is how unions are referred to under the statute. Section 7 includes the right to engage in concerted activities, so not individual activity, but concerted efforts by one employee to get other people involved or by a group of people for mutual aid and protection. That means that you are trying to achieve some sort of goal which will help employees in the workplace. The employer may not believe it's helpful, and that frankly doesn't matter. If the employees believe that it is something that would benefit them, they may be seeking a wage increase that the employer could never afford. It could be some sort of demand that could put the company out of business in some situations. But if the employees believe it is in their mutual aid and protection, it is very likely to be protected. And the key thing is These activities need to somehow relate to wages, hours, and terms and conditions of employment. So not all together. So it could be a demand on wages. It could be we need a different schedule. We need to stop working 7 days consecutively in a week. It could be terms and conditions of employment. We don't like the candy machine that you put in our break room. If you have a group of people making a complaint about it, that is going to be protected under this law. Something that is often overlooked but is very much a part of Section 7 is the right to refrain from activities. You, employee, have the right to say no. And if you have employees who want to form a union, you can say no. If you have employees who want to protest some working condition, you have the right to say no, I choose not to participate. So at the heart of this statute, Section 7, is a right of choice. Whether or not to participate in activities, you do have the right to say no. The overview of this law and these rights involved Congress enacting the National Labor Relations Act in the 1930s while Franklin Delano Roosevelt was president. We were in the Depression. This was considered a form of economic stimulus to basically avoid a situation we had across the country where different states had different rules on labor relations. Strikes were happening in certain places. Unions were perhaps more active, more healthy in some parts of the country. This law, the National Labor Relations Act, set a uniform standard across the country for rights and enforcement of law to protect those rights. The National Labor Relations Board, or NLRB, as we call it, was established by this law to enforce the law. The law has been amended at different times. There were some big amendments in the 40s. There have been amendments since then. But the Act serves to promote those rights under Section 7 to unionize. No union, no employer can interfere with or coerce employees in exercising those rights. Now, question arises, what businesses does this apply to? Does this apply to government? It applies largely to the private sector. So private business, not government. One exception is the U.S. Postal Service, which is the lone government agency regulated by the National Labor Relations Act. Most public sector employees are governed by similar statutes, not identical, but they are enacted by states. There are some federal statutes for, say, federal employees. There are some other guidelines that apply to local and municipal employees. But NLRB is private sector. The role of the NLRB is to enforce this law and to protect the parties covered by the law, principally employees. And this can mean prosecution of employers or unions to protect those rights. And as a result, the NLRB's role can be quite controversial, quite political. And while I will not take political sides in discussing these issues, it's important to know as you practice this area of law that you need to be somewhat aware of the political tides. Who is president affects who is appointed at the highest levels of the agency, as general counsel, as board members who decide cases. And what happens from one president to another affects the appointments, affects the policies and priorities of the individuals who are put into those offices. The National Labor Relations Board is headquartered in Washington, D.C. It's run by presidential appointees who are typically confirmed by the United States Senate. Now, that has been an issue which has come up in recent years. In fact, the United States Supreme Court in the last couple of years ruled in a case called Noel Canning, where the issue of the president's authority to put people on the NLRB without Senate confirmation was addressed and somewhat limited compared to what the White House believed it could do. So National Labor Relations Board appointments typically must be confirmed by the Senate. This includes board members as well as the general counsel. And the board, the 5-member panel that the president appoints, decides cases and makes rules. The general counsel runs the day-to-day operations, which include the field offices across the country. there are what are referred to as regional offices from coast to coast. And as I mentioned, due to the politics, there is some sway in policy from time to time. As a practitioner who's been dealing in this area for 27 years as of the time of this recording, there are rules of law which have gone back and forth, depending upon who is president at the time. So one thing that is reliable in dealing with this area is whatever the law is today may not be the law by the time your case goes to trial. So it's important to recognize there is some fluctuation in the law and a need to stay constantly attuned to the developments and the rulings. This is an agency that does not rely heavily on regulations, but instead the case precedent of the board panels that sit on cases and review what goes on a day-to-day basis. The board's Washington, D.C. headquarters run regional offices throughout the U.S., but there is a lot of autonomy of the regional directors in the various regions across the country. California has 4 NLRB regions and 5 offices. Region 20 is based in San Francisco and covers Northern California. Region 32 is based in Oakland, covers Northern and Central California, Northern California is somewhat south of where Region 20 covers, and down to around Fresno and Central California, and it also covers Northern Nevada. Region 31 is based in West Los Angeles and covers Los Angeles and North Kern County, San Luis Obispo, and so forth. Region 21, my former office, is based downtown LA and covers Los Angeles County, Orange, Riverside, and South. San Diego has its own office, which is a resident office, a branch of Region 21. It covers only San Diego County and Imperial counties in California. And depending upon where your issues arise, and you want to pay close attention to how the regional boundaries are drawn, that determines where you file your case. If you have an unfair labor practice charge, which we'll discuss a little later, or an election petition, which we'll discuss later, that will determine where you want to go. The National Labor Relations Board, in doing its work, plays 2 very different but interrelated roles. One is to run elections, and that is the process by which employees vote and decide whether or not to have union representation. With the number of union members going down, there haven't been as many elections in recent years as there were, say, 10 or 20 years ago. The other job of the National Labor Relations Board, and one that is quite busy, is unfair labor practice charges. And what the agency does there is they receive charges, allegations from unions, employees, employers, that a union or employer has violated the law, and the Labor Board will assign an investigator and will investigate as a neutral. The way the NLRB describes it, we are collecting facts. We will make a decision whether there is merit on the case, whether to accept or reject these allegations. If we reject the allegations, they will be dismissed absent a withdrawal. If we accept the allegations as having potential merit, the NLRB will decide to prosecute, and we'll take those cases to trial before an administrative law judge. We'll talk a little bit more about this process as we go on. Representation cases, the election process. There are different types of elections. There are certification elections where a union is trying to become a representative of employees, a group of non-union employees typically. Sometimes it could be a group that is represented by one union and a second union wants to come along and unseat the first union. That would still be a certification election. There are decertification elections where there is an incumbent union and perhaps a group of employees wants to remove that union. The union has lost support. And there are certain opportunities. It's not a constant opportunity. There are window periods under the law for employees to say, I would like to decertify and have a vote to remove that union. Another type of election is deauthorization, where there is a union relationship and there will remain a union relationship, but an election is held where employees are given a vote. That vote is on something called union security. And in some states, states that are not right-to-work states like California, California allows what's called union security, where employees have to pay dues to the union in order to be eligible to work. And deauthorization is a vote by which the employees vote whether or not to remove that requirement from their contract. Do we have to pay dues as a condition of our employment? And if a union is deauthorized, the relationship remains in effect, the contract remains in effect, the union security provision is essentially voided. The election process begins with a petition form. The petition is available in the forms library on the NLRB's website, nlrb.gov. It is a one-page form which requires an employee or a union or whoever is filing the petition to list the name of the employer, the contact information, the group of employees that would participate in the vote. For example, if you're in a manufacturing company, you may want the people working on the production lines and shipping and receiving. They would be the inclusions in the vote. And you would have exclusions, who would be your supervisors, your office clericals, your guards and supervisors. So they would be distinguished in the petition. And whatever that grouping is that you want to have, it could be different from what I described, and it could be different for every workplace. The petitioning party, typically a union, will want to have a 30% or more showing of interest. What this means is at least 30% of the employees in that group that you requested, production lines, shipping and receiving, or whatever the group is, you want to have at least 30% of the employees signed to cards or a petition which identify the employee and the date of signature, among other information. Typically, it's an index-sized card that an individual employee will sign saying, I wish to be represented by name of union, and I want the union to engage in collective bargaining for me. That's typical if you're going to have an election on certification to bring in a union. If it's an election to remove a union, it might be a petition saying, we, the undersigned employees, wish to remove name of union as our representative, or something like that. And it needs to be signed and dated. There's a new NLRB policy which now allows electronic signatures for showing of interest. So rather than union representatives going out and handing out cards to employees outside a workplace, or employees handing them out at work and being spotted by supervisors, which they hope to avoid, doing so electronically will be quicker and more discreet. The NLRB will allow this for the first time ever, as of just a few weeks ago. A union must, in any case where there is an election, receive a majority of the valid votes cast in order to represent the employees, in order to win. In a tie vote, the union loses because it's not a majority. So this is giving a very short summary of the process, which we'll talk about a little more as we go on. The union's winning percentages have increased in recent years. The unions are now winning about 70% of the NLRB elections in the workplace. Even so, they believe that the process is flawed, they believe that the process is too slow, and they believe that they are going to lose ground without changes in the law. there have been some newly implemented NLRB rules affecting the election process. And the process, the time it takes, how it works is a highly controversial issue these days and may well see change again in the future. The President was a big advocate for the recent rule changes adopted in April 2015, and he has already spoken out in favor of additional labor law reforms in the months after those rules took effect. So stay tuned, this may well be changing. The National Labor Relations Board has been focused very carefully on the timetables for elections in the workplace. And one of the things that the Labor Board hopes to do is to ensure prompt workplace elections so that employees and their choice is protected and acted upon in a reasonable amount of time. In the late 80s, early 90s, when I worked for the NLRB, elections were held in about 49 days. That means from the time a petition was filed where a union says, I wish to represent this group of employees, until the day of the vote, it would be about 7 weeks. And there would be a number of things that would happen leading up to that time. The employer and the union might have a hearing, they might have an election agreement, there might be a campaign, there might be efforts by both sides to sway the employees on how they should vote. Yes, for union representation, no, against union representation. But that time frame, roughly 49 days, sometime less, was something that the Labor Board tried to live by. And it was very important to them in statistical reporting to headquarters that they were enforcing and effectuating their rights under the law. The time frames have decreased over the years. Under the Clinton administration, as I mentioned, we see changes depending upon who's in office. It was a priority to shorten the time frames, and the time frames went down to a span of 35 to 42 days from the time an election petition was filed until the date of the election. And there was a lot of outcry, particularly from employers on that issue, saying that it would hamstring them in communicating with their employees, in dealing with the uproar in the business, and potential disruption of having an organizing campaign. We had a 35 to 42 day election period in effect from the mid-90s until April of 2015. Now, with the new rules that took effect in April 2015, there is no timetable spelled out in the rules. And it has been anecdotal and through outreach from the agency that information has been gathered on what the rule, what the internal guidelines were. Since the rule took effect, we have seen that it is typically now closer to 25 days from the time a petition is filed until a vote is held. And it's been reported that an election has been held as quickly as 10 days after an election petition was filed. And the Labor Board has, in many ways, shortened up the process and done things to move things along to reduce litigation. We'll talk about that. A 10-day election would be exceptional. In an outreach session in Los Angeles in early 2015, one NLRB official said that the quickest possible election under the current rules from petition filing to voting would be 3 days, and that would involve waivers of some time periods allowed under the rules. 3 days, which is quite quick. So there's a lot that goes on when you have an NLRB election, an automatic hearing being put on calendar, the possibility of an election agreement to avoid litigation, and many other steps such as campaigning before Election Day. On this slide, we talk about the rules that took effect in April 2015, which are fairly new, but very important, because if you represent employers, you want to be sure that you are mindful of additional requirements. If you represent unions or employees, you want to see whether the labor board is holding employers to these requirements, and there may be opportunities for you to raise issues if an employer has not spoken up and filed the right materials in order to take a stand. An employer must furnish a new document called a statement of position by the 7th day after the election petition is filed, no later than noon. It's actually in the rules, no later than noon, to outline whether it will agree to including a group of voters as the union describes in an election, whether there are any other issues that impact an election, and if the employer does not furnish this statement of position, it is barred from raising issues on the voting unit, on the eligibility of individual voters, whether someone is a supervisor or not. So you need to know and file on those issues by that 7th day at noon. Otherwise, you are precluded. There are going to be fewer hearings and more election agreements. And this is because the Labor Board has decided not to allow much litigation anymore, figuring that litigation simply causes delay and that most issues are so routine that they can be addressed after the election. Many management side attorneys are concerned about that because there are potential issues affecting supervisory status, whether someone is management or an employee, among other things. There's a lot to be seen and said on these rule changes as time goes on. There is more discretion and control in the local NLRB offices, more autonomy and less oversight by the board panel appointed by the president in Washington, D.C. You're going to see less issues resolved, more open questions when cases go to a vote. Is somebody truly an eligible voter? Is there some question of misconduct by someone who was a supervisor or believed to be a supervisor? Things like that. One of the most controversial changes in these new election rules is the voter list. Historically, the Labor Board has required an employer to supply a list of eligible voters and their home addresses to the NLRB after an election agreement or a hearing has been held and a decision made on who will vote. And the union gets a copy of that list, or used to, from the NLRB to send out campaign letters, to try to visit employees and to convince them to vote for the union. That was called an Excelsior list. Under the new rules, the employer has 2 days from the time an election agreement is signed or the Labor Board rules on an election being held to supply not only full first and last name and home address, but also home phone, cell phone if the employer has it, and personal email of the employee. So there are a lot more ways for a union to reach out to the employees to campaign, and this is something that the employer must furnish directly to the union as well as the NLRB. Let's say you have these unresolved issues that you weren't able to litigate. What do you do after the election? Let's say you believe that the other side engaged in misconduct. You have a right within 7 days to file objections as a protest of the election. If you don't file objections, the results will be certified. If a union wins the election, it's called a certification of representative. If the union loses the election, it's called a certification of results. If the objections are filed within 7 days, the issuance of a certification will be suspended. The Labor Board will conduct an investigation and possibly a hearing of the issues, or on the issues under the objections. And the Labor Board is going to try to expedite the holding of those hearings according to the new rules. Now, Sometimes there are issues involving the voters that people could not agree were eligible, what we refer to as challenged voters, challenged ballots under the NLRB process. And if there is an eligibility issue, or if there are issues in a number which affect the margin of the vote, then the Labor Board may also investigate and hold a hearing on those issues. It could be consolidated with objections. That does happen fairly regularly. And again, if you have a difference in the vote, if it's 20 to 10 and you have only one challenged ballot, that's not determinative. It will not get attention after the vote. If, however, it's 10 to 10 and you've got an additional 10 challenged ballots, that does affect the margin, and the Labor Board would look into that to do the math and to determine, is somebody a supervisor? Do they work in the right facility? Did they vote in the right place? Things like that to determine whether that vote from each individual should be counted. So we often see during organizing campaigns in the period leading up to elections that one side or the other will accuse the other of violating the law, engaging in unfair labor practices. This is separate and apart from objections, conduct which is alleged to affect the conduct of the vote, and instead is alleged to be interference with employees' protected rights. Sometimes the issues will overlap, but a charge must be filed for it to be considered an unfair labor practice issue or investigation. Both unions and employers are prohibited from different types of conduct under the National Labor Relations Act. It's usually viewed as a form of coercion against employees' protected activities, and there is a 6-month limitation period in which to file a charge. That's under Section 10B of the National Labor Relations Act. The forms for filing charges against employers or against labor organizations, which again is the statutory name for unions, those forms can be obtained in the forms library at nlrb.gov. Typical allegations against unions or employers where unfair labor practices are alleged would be things like unlawful statements. You threatened me because I'm supporting the union. You interrogated me or asked me questions about whether I support a union or not. You're not allowed to ask an employee those questions. You made me a promise. You offered me a raise if I would refuse to support the union. You engaged in surveillance, actual or implied, where you followed me around to the union meeting. You asked me, did you talk to that union representative outside? I saw you talking to that guy who was handing out cards. Those sorts of things are unlawful statements. They may impact employees' union activity, and then again, they may not. The Labor Board does not look at the actual impact of the statements that an employer or a union is accused of making. They follow what they consider an objective standard. Does the statement which was made tend to interfere with employees' protected rights under Section 7? So if an employer or a union representative says, well, yeah, I said it, but it was a joke, that's not a defense. Discrimination is another issue which comes up in unfair labor practice charges, a very common allegation along the lines of retaliation. You fired me, you disciplined me, you treated me different in work assignments or pay or some other aspect of work because I support a union, because I made a concerted activities complaint with other workers to ask for gloves in the workplace. Because I complained about a supervisor, something like that. Refusals to bargain in good faith, that could be a violation by either an employer or a union. When you have a unionized workplace, an employer and a union have a reciprocal duty to sit down and to bargain. They do not have a duty to agree necessarily. They have a duty to act in good faith, to meet, exchange proposals, to to negotiate and to make their best efforts to reach a deal. If they have gone as far as they can go, they have no further room to move, they have acted lawfully, then negotiations may reach a lawful point of impasse where negotiations can break off. The bargaining relationship does not end, but this is often a dicey, detail-oriented issue. So employers are definitely in need of good and careful legal advice on how to handle these issues. Collective bargaining can be complicated. Unions likewise need advice on these issues to make sure that they are bargaining lawfully. Many times parties will ask for information to understand the other's proposals, and there are duties as part of the bargaining duty to provide information, to review information and proposals and so forth. But again, no duty to agree. There's often the misconception if a company unionizes that the employees will have a brand new union agreement almost automatically. That is not the case. The parties will have a duty to bargain. And again, that bargaining duty is very nuanced. The types of allegations that can arise in unfair labor practice cases will take different forms. And the legal standards flow from case law that the Labor Board has developed and which has had ebbs and flows since the 1930s when the National Labor Relations Board came into existence. There are certain types of unfair labor practice activities that are unique to unions. This includes blocking ingress and egress to a workplace, violence or threats of violence during protest activity, threats of picketing against companies with a goal of putting pressure on another company. We see this, for example, when a union pickets outside a construction site, and they're picketing supposedly for because of a dispute with one company that is not at the site, but there are other people who are scheduled to work there. Or if you have a union picketing outside a store which does not adequately identify that it's the products of one company that are being protested, and instead they're saying don't do business with the store. Those are what are referred to as a secondary boycott. There have been issues along those lines involving stationary banners and flyers. Those have been raised as secondary boycott issues. There has been some leeway by the court and by the NLRB to recognize that type of conduct as protected free speech rather than unlawful secondary boycott activity, but again, heavily detailed and must be looked at very carefully. Other issues that unions can get involved in might involve threats or picketing of an employer with the object of forcing or requiring that employer to bargain with and recognize that union when the employer has run a non-union operation. In other words, the union pickets, they want to be recognized, they want a contract, and the employer doesn't want that. If the union pickets for a reasonable period of time not to exceed 30 days, that may be unlawful. So those are a very quick summary of issues on unfair labor practice allegations that may be raised. The development of the law has been very lengthy over the years. The National Labor Relations Board and the federal courts have looked at the statute, and all of it begins with the filing of a charge, that charge form off the NLRB website, the investigation by a board agent, and witnesses giving testimony at the regional office, typically of the NLRB. The agent will review that evidence with the supervisor and the agent will review that evidence and the issues with the regional director, and that will be the basis for the director's decision whether or not to prosecute. Roughly half the charges the NLRB receives result in further proceedings, and then about 90% of the cases they decide to litigate end up settling before trial. There are some exceptional unfair labor practice cases where the labor board says This case involves such severe misconduct that our processes are not adequate to remedy the situation. In those situations, the regional offices can request authority from Washington, D.C. headquarters to sue the employer or union in federal court for an injunction. And there are two types of NLRB injunctions. One is under Section 10J, one is under Section 10L. 10L is typically an injunction against certain types of picketing, like I described, by unions. Section 10J is for everything else. Let's say 10J is sought. There is an injunction. You have federal court contempt issues if you breach that injunction. It is a low bar to get an injunction. It's sometimes hard to get NLRB to take that step of going 10J, but if they do and you get that injunction, it is a low bar, and you need to be mindful of contempt and federal court procedures in addition to the standard administrative process, which will be very likely running as well. So you could have a 10J litigation going, you could have administrative litigation going, and a trial before an administrative law judge. And the 10J is very likely to move at its own pace. So if you have a hearing through the standard administrative process, the administrative law judge will receive testimony, exhibits, and make a decision which can then be reviewed by the National Labor Relations Board panel in Washington, D.C. In the ordinary course, the panel will review those decisions and may modify certain findings if they see fit, may modify certain rules of law if they see fit, or if it's a hot topic issue where they have expressed some interest in modifying the standard. We've seen quite in recent years. If a party disagrees with the judge's decision, they can appeal through a process known as exceptions. If you file exceptions and a supporting brief, the 5-member board in Washington, D.C. will more likely give closer review to the case and address the grounds raised for exceptions. So in filing with the 5-member panel, that is typically done electronically. There is no oral argument or hearing in Washington, D.C. or otherwise. In most cases, it is done on the papers and through the e-filing process. Let's say you're dissatisfied with the board's ruling. What do you do? Do you have any recourse? Yes, you do. You can go to a federal court of appeals in an unfair labor practice case. You do not have such a right of appeal in election cases, representation cases. What often happens as a result is, let's say a union is found to represent employees and the employer disputes the fairness of the election. There may be a refusal to bargain charge filed against that employer, which the employer then takes up into the courts using the process I'm about to describe. In California, if you are the losing party before the NLRB on an unfair labor practice charge, you have a choice of where to take your case. You can go to the Ninth Circuit, which is your home circuit, or you have a statutory right to go to the District of Columbia Circuit in Washington, D.C., where you can file your papers and then you may have oral argument in Washington. That's something that you need to apply for admission with the D.C. Circuit as you would with the Ninth Circuit. It's something that anyone practicing labor law is advised to consider in order to offer those sorts of options to your clients, be they employers, unions, or employees. Some rare cases move from the Circuit Court of Appeals to the U.S. Supreme Court. That's if the court grants certiorari. We've had a couple of prominent NLRB cases reach the Supreme Court in recent years, and in many instances, the courts give the NLRB deference as an administrative agency. In interpreting the statute, it's charged with interpreting and enforcing. But we've seen in situations like the Noel Canning case, which I mentioned, and a case, New Process Steel, a little bit before that, where the the court has, I think, given less deference and raised questions with how the appointment process worked and the composition of the NLRB in the new process steel case. So it's important to know that you have these different layers of potential review. Sometimes they are very strategically important to incorporate in discussing with your clients and also discussing budget, because these cases can sometimes take not just a few weeks or months, but they can drag out for a matter of years. And it's important to know where you can go, how long it might take, how much it might cost. A losing party NLRB may face a number of remedies, and the typical remedies would be the posting of a notice, reinstatement of a employee, rescinding discipline which was improperly given, back pay for economic losses. That could include lost wages or benefits. The NLRB has authority which is regarded as make whole. In other words, undo the wrong, put people back where they were before. It could be an employer providing a make whole remedy. It could be a union. There are no fines or penalties under the National Labor Relations Act. There have been a number of proposals, and there's pending legislation as we speak that would provide for penalties and back pay ×3 and different sorts of mechanisms to discourage employers in particular from violating employees' Section 7 rights. Because technology is such a significant part of the workplace and how people interact, the Labor Board has also implemented a process by which if you communicate electronically with your employees, email, intranet, or otherwise, you are required to post your notice to employees, part of an unfair labor practice remedy, electronically as well. You would disseminate that possibly via email, via posting it on your intranet, whatever is applicable to your workplace. Some of the emerging issues before the NLRB as we approach the end of the program, I want to make sure and touch on these because they are getting a lot of attention, some more than others these days. The protected concerted activities I've touched on a bit. That is part of the Section 7 rights. It's important to remember that a non-union employee, a non-union workforce, has rights under the National Labor Relations Board and the National Labor Relations Act. And employees can go on strike without a union. I had a case when I worked for the Labor Board that I prosecuted where an employer let go a group of janitors in a non-union workplace because they complained about their wages. The employer argued they quit. They abandoned their jobs. But it ended up being a six-figure verdict because the employees were deemed to have engaged in protected concerted activities. They went on strike. And when they were relieved of their duties and told to leave under threat of arrest, it was a discharge for engaging in protected activities. So they were offered reinstatement, they were given back pay, and it was a remedy in addition to a notice posting for what had happened to them. So be mindful that these activities can occur in the private sector in non-union workplaces. Handbook policies are very important. Different policies affecting employees' rights to communicate, requiring confidentiality. There's all sorts of rules that can get the attention of the NLRB. No moonlighting policies, solicitation and distribution policies, which may say nothing about a union, but very much regulate how employees discuss and interact in the workplace on issues including unions. And if they are drafted properly, that's part of the issue. And that's something I recommend you have reviewed at least every couple of years to make sure your policies on these and other issues are up to current legal standards. There's also an issue at NLRB of how consistently you enforce the policies among your employees, and whether they are enforced more strictly with union supporters, for example, than with employees who are opposed to a union. Arbitration agreements, as I mentioned, those class action waivers, among other things, remain hot topics. The NLRB's position is at odds with most courts, but the Labor Board says we'll let the Supreme Court decide that if and when it ever comes up. They continue to prosecute those issues. Social media is an area of booming growth for employees to discuss their issues in the workplace. They're discussed with supervisors, pay practices, workplace practices, and increasingly the Labor Board is telling employers and employees, look, this is how people communicate these days. If they're talking about wages, hours, and working conditions, it is something that is potentially protected, even if it's offensive. And it's something where employers may take issue with what is said or how it's said, but more often than not, the law is going to allow employees a certain amount of leeway in even insulting and name-calling with their supervisors. We're seeing more and more of that all the time, and the standard has become quite broad in what employees are allowed to say. Joint employer standards are a hot topic now because the Labor Board just issued a ruling in a case called Browning-Ferris saying that they're going to overrule long-standing rules of law and essentially enable a union to organize a combination of employers. It could be two employers who have common control or potential control over the workplace. It could be a staffing company working together with another company. It could be a joint venture. It could be a number of situations. But there's the potential for joint representation. There's also the potential for joint liability if there's an unfair labor practice. Very, very hot topic. This ties in with franchisors and franchisees. NLRB is currently prosecuting McDonald's franchisors on the basis that they are joint employers and liable for unfair labor practices. And the corporation says we are not responsible for what our franchisees do. They operate independently of us. The Labor Board is saying they would not operate the way they do, but for the way the corporation tells them to do it. It's under your brand, and you exert a high level of control. This is highly detailed, but this is going to be one more level at which the NLRB is attempting to bind multiple companies to common obligations. There's been some attention on college athletes as employees. There was an election petition at Northwestern University where the Chicago regional director ordered an election and found the football players to be employees who had protection and the right to union representation under the National Labor Relations Act. The panel in Washington, D.C. very recently closed that case, finding it to be a bit too complex for the NLRB to handle, that it would upset the chemistry of college football, and you call that what you will. I think this is an issue that's not going away. We are seeing people in the educational setting being organized in other ways, graduate students and so forth. I would not be surprised to see further efforts to get the NLRB to pursue college athletes as a potential for employees and union representation in the future. There are a number of legislative reform efforts coming from a variety of perspectives, people who are union advocates, people who are management advocates and not so friendly to unions, and so forth. And basically you can have, I think, a good guess at what sorts of things they want, but many management advocates think the labor laws are being too aggressively enforced and rights being too expanded. Many unions feel that the process is not working as it is and needs to be made, I think, easier for unions to organize and employees to have broader and more meaningful rights. So there's a lot of debate yet to be had on these issues. There are a number of resources available to you if you are interested in looking further at what is provided in the way of rights and processes. The National Labor Relations Board website is very informative, nlrb.gov. The State Bar of California has a labor and employment law section, of which I sit on the executive committee as an officer, and the publications and programs that this group presents are very good and serve to educate the legal community. They are on a number of topics, including traditional labor law and the National Labor Relations Board. You may want to look there. There are additionally a number of other organizations and websites which provide good information and current information on what's happening at the NLRB. This is an area of law where, when I got into it 27 years ago, people said, unions are dead. Why are you getting into this area of law? I have stayed busy with this area of law for 27 years, and it is a ripe area for growth. It is a ripe area for people to, I think, learn more, develop a specialty, and know how to do something very key, very important to the workplace that is outside the niche of employment law itself. Thank you very much.